Hello and welcome back to another video. In today's segment, we would learn what do you mean by alteration of share capital. So alteration, from the very word, it is clear that there is either an increase or a decrease in the share capital, or there is some change in the share capital of the company. So we would see the introduction to the topic. So share capital alteration means an increase or decrease of authorized share capital of a company. Now, what do you mean by authorized share capital? We would see in the further slides. But an increase or decrease in the authorized share capital is there is some change, and that change is called as alteration of share capital. The Companies Act 2013 allows the companies to alter or make some changes in its authorized share capital. So there is a provision in the Companies Act which provides for such alteration, which authorizes the company for such alteration. Now, the power of the company to alter its share capital is defined and explained in Section 61 of the Companies Act. So Section 61 specifically of the Companies Act 2013 has provisions which empowers a company to alter or bring some change in its share capital, and it is clearly defined and explained there in Section 61 of the Companies Act that how a company should move on and alter the share capital which is already predefined in its structure. So alteration in the share capital can be done only if it is so authorized by its article of association to alter the capital clause of its memorandum of association. So this alteration, although it is given in Section 61, but Section 61 also speaks that it can only be altered if the article of association of the company, which is already framed at the incorporation time, if that particular article of association authorizes or permits or allows the company to alter or bring about a change in its share capital, then only such change or alteration can be made. Now, the next we would see is Section 61 of the Companies Act. So Section 61 says that if a company limited by shares or guarantee is authorized by article, can alter its share capital by passing ordinary resolution its memorandum in following ways. So that says that if the article of association of the company permits, then there can be change or alteration in the capital clause by passing ordinary resolution. So ordinary resolution means that you don't need the permission of the tribunal to bring about a change in this particular segment. But if all the members and all the shareholders agree commutatively upon the particular thing, then this article and if the article permits, then the alteration of share capital can be done. Now, how can it be done? So the memorandum says the following ways are there in which the alteration can be made, and such alteration has been defined under Section 61. So the ways are, it can increase the share capital. So can increase. Then next is, it can consolidate all or any of its existing shares in larger denomination. What is all this? I would just tell you in the very next slide. For now, we would just look into the briefings. Next is, you can alter the share capital by converting all or any of the share of the company into larger denomination. Also, it can be done by subdividing the existing shares into smaller denominations. Next is, the shares which are already there, have been existing in the market, such shares can be forfeited or cancelled. Forfeiture or cancellation is the same thing. So such shares have to be cancelled or forfeited if they have not been paid up. Now next we would see that how different types of alteration takes place in the share capital. How can you alter the share capital through different ways? So the very first way is by increasing the authorized share capital. So now we would see, what do you mean by authorized share capital? So authorized share capital means the registered capital at the incorporation time. The company must have kept some amount of capital as the registration capital. So that capital, or the nominal capital which we call it as, is the authorized share capital, which was placed at the time of incorporation of the company. So the company can raise its share capital by doing alteration in the capital clause. So this authorized capital can only be altered or changed if the alteration is permitted in the article of association of the company. And if the article does not permit it, then there are several steps which have to be followed before alteration of share capital of authorized capital can actually take place. Next is consolidation of share capital. Consolidation means that you join the smaller shares together to make it a larger denomination share. So the company has also this option available with them to consolidate the smaller denomination share, the shares which are of smaller value. They can combine those shares and convert it into larger denomination shares. Next is conversion of share capital. So the company can also alter its capital by converting the fully paid up shares. Now, what are fully paid up shares? Suppose a share is of a face value of rupees 10 and the company has called up for entire rupees 10 value, or some of the members have already prepaid the entire amount of the share, then such shares can be converted into stock, and such shares where the full amount has been paid is called as a fully paid up shares. So the company can also alter its capital by converting these fully paid up shares into stock, or there is another option as well where the reconversion of these stocks can be done into fully paid up shares as well. Okay. So next is subdivision of share capital. Now what is subdivision? Subdivision means that the shares which are there with smaller amount, or the shares which are there existing already, that was fixed by some amount, that was there fixed with some amount, such shares can be further subdivided and made into smaller or denominations as prepared by the company. Okay, so this is subdivision of share capital. Next is cancellation of share capital. So there are some shares which are not taken up by any person, or there are some shares which the person take up but they do not pay the amount. They are not fully paid up. Like the company called for it, but the member, they forfeited in the payment. So such shares are cancelled. So when such shares are cancelled, the amount of the share capital also can be cancelled and decreased by such amount. So this is cancellation of share capital. Now, next is procedure for alteration of share capital. Now, what is the exact procedure which you follow while you alter the share capital? So there are three ways in which a share capital can be altered. First is by if the article of association authorizes. So this is very common. In the entire video I have been telling you this, that if the article of association permits, then only there can be alteration in the share capital clause of the share capital. Okay. Now, there are other ways as well. By resolution. Okay. If there is no clause which is specifying that in the article of association, if there is no clause in the article of association which is specifying that the alteration of share capital should take place, then there is a resolution, special resolution passed, wherein there are several steps. Will not go into that depth, but there are several steps wherein the members agree upon something, the special board meeting is called upon, and then they go to the tribunal and take the permission, and finally first they alter the article of association, and thereby they bring about a change in the alteration in the share capital. Okay. So these are the two ways, and the next is notice to registrar. Now, what is notice to registrar? Is notice of alteration is given from the hands of the company to the registrar, and there is a period specified. So a period of 30 days is given to the company to just go and give a notice to the registrar that they want to alter the share capital. And if the company fails to do this, then the provisions are there which moves to a heavy penalty. If they alter the share capital without the notice to the registrar within the limited period given, which is of 30 days, then there is a hefty penalty which the company has to pay. Now we would go in the depth of how the procedure is to be followed. So, procedure followed for alteration in share capital. So, the very first thing is a board notice is given regarding the agenda of the meeting, that what agenda is to be followed, and that notice is given 7 days exactly before the date of the meeting. So if the meeting falls on 17th, suppose, so 7 days before, that is on at least on 10th of the particular month, the notice shall be given about how the meeting is going to be and what is the agenda of the meeting that is to be taking place. And then a board meeting has to be taken place. Normal meeting is not going to do anything, and board meeting with a special resolution takes place and members are invited. Next is the resolution for the alteration of share capital is passed in the board meeting. So there is a board meeting held and the resolution for the alteration is particularly passed in the board meeting. Then the resolution which is passed is also the subject of the approval of shareholders. If the shareholders do not approve of such alteration, then such alteration cannot be carried upon. So shareholders approval is very, very necessary while you want to alter your share capital. Okay. So the resolution which is passed in the board meeting has also to be approved in the shareholders meeting, and if the shareholders agree to such alteration, then the further steps are to be followed. So for holding a shareholders meeting, what you have to do is you have to fix a date, time and venue for the meeting, which is commonly done for all the meetings. And then director is authorized to send notice to the shareholders. So the director, he sends the notice of such meeting to the shareholders, and the notice should be issued at least 21 days of the meeting. So when the board meeting is being conducted, then 7 days of notice is required, and when the director is sending a notice to the shareholders for such alteration, then at least 21 days of notice period is required to call upon the meeting of the shareholders. Then next is shareholders meeting is held and it is conducted, and then the resolution with the consent of the majority shareholders. So if the majority of the shareholders agree upon that yes, we would convert, we would alter the share capital, then yes, that resolution would be accepted. Otherwise, if the majority of the shareholders agree upon that no, we are not going to alter the share capital, that is not required at the moment, then such resolution as passed by the shareholders majority would be accepted. So it depends upon the shareholders that what decision they are actually bringing upon. Next is, once the resolution is passed, then this resolution is taken up to the registrar. So registrar is notified about this alteration in capital within 30 days. Now after this 21 days of meeting being conducted, then once the meeting is conducted, then within 30 days of that meeting being conducted and passing of the resolution, the registrar should also have this notice, this knowledge, and he should have been notified that there has to be alteration in such and such limited or private limited. Okay. If the registrar is not notified within 30 days, then the company again faces a hefty penalty on it, which is they are liable to pay a fine of rupees 10,000 for each day of delay. Now it is not the maximum amount. It is 10,000 per day. Every passing day after the 30-day period, every passing day has a penalty of 10,000 levied upon the company, and that fine can be extended up to rupees 5 lakh. Now the last step is, based upon the resolution passed, the company has to fill in the forms. So if a special resolution is passed for the alteration of the company, then the company has to file form MGT 14 with the registrar of the companies. Okay. But if the ordinary resolution is passed, now what is ordinary and special resolution? Special resolution is when the article of association do not permit such alteration of share capital, then what happens? You call upon a board meeting and then you decide upon, and then several steps are taken. First, to alter the article of association, and then after alteration of article of association, once it includes this provision of alteration of share capital, then form MGT 14 has to be filled to bring a special resolution for alteration of share capital. An ordinary resolution is when article of association already has this provision incorporated that alteration of share capital can take place as and when required, then simple ordinary resolution is passed. When ordinary resolution is passed, then form SH7 is filed with the registrar of the companies for alteration of share capital. Now, how these forms are to be filed? These forms are filed on the prescribed fees on the side of Ministry of Corporate Affairs. If the forms above mentioned are not filed with the registrar of the companies, if you fail to file these two forms accordingly as per your resolution with the registrar of the companies, then such company under section 117 of the Companies Act is liable for a fine which shall not be less than 5 lakh rupees, which shall not be less than 5 lakh rupees, means 5 lakh is the minimum amount, but it will extend up to 25 lakh of rupees. Plus, every officer, every member, every officer of the company who is involved during this time will be liable for rupees 1 lakh, which will be extended to rupees 5 lakh. So, this is all for alteration of share capital. I hope you have understood and you have liked my video. Thank you.